Good afternoon, everyone. My name is Paula Shapiro, and I'm the Associate Director of the American Bar Association Section of Civil Rights and Social Justice. Welcome to the latest webinar of the ABA's Rapid Response Program. A major priority of this year's Section Chair, Rob Weiner, is to respond promptly to actions of the administration that impact civil rights, civil liberties, and social justice. The section of civil rights is the only membership section of the ABA devoted to working on civil rights and social justice issues. Our members work to ensure that the world's largest voluntary professional organization continues to uphold the Bill of Rights through various action, including public advocacy and education, drafting amicus briefs, congressional testimony, providing CLE and committee work, and additional programs and publications that inform and inspire. We would love for you to join our efforts. Today's program, A False Sense of Relief, Asylum in the Trump era, is a follow-up from October's A False Sense of Relief program. The program will be moderated by Michael Tan, staff attorney at the ACLU's Immigration Rights Project. Michael?
Hi, everyone. Thank you. Again, I'm Michael Tan with the ACLU. I'm very happy to be here today. And a big thank you to the ABA for convening us. And of course, thanks to all of you for joining online and on the phone. Today, we're going to continue our conversation about asylum in the Trump era, the new challenges we're facing to constitutional and human rights, and what strategies we as the bar can pursue to defend our clients and immigrant communities from the administration's crackdown on asylum. So I'm going to start off the program by describing some trends in the detention of asylum seekers that we've been seeing since January. Immigration detention is my particular area of focus at the ACLU. I'll also provide an update on our case pending before the Supreme Court right now, the US Supreme Court, challenging long-term or prolonged immigration detention. That's a case called Jennings against Rodriguez. We'll then turn to my wonderful co-panelists, Sandra Grossman and Nancy Aretskin, to share their experiences representing asylum seekers under the Trump administration. And then we'll leave the remaining time for discussion and questions from all of you. So, brief introductions. Sandra Grossman is the founder and managing partner of Grossman Law, LLC, a full-service immigration law firm in Bethesda, Maryland. She's an experienced litigator, having successfully represented individuals before the immigration courts, the Board of Immigration Appeals, and the federal district courts. She's a former adjunct associate professor in immigration law at the Washington College of Law, American University, a member of the editorial board of Bender's Immigration Bulletin, a contributor to Huffington Post, a former vice chair of AILA's Asylum and Refugee Committee, and very much has a lot of experience to share with us today about asylum work. One last thing I'll add is that she's counsel for Amos Yee, an asylum seeker from Singapore whose case was widely reported on by national media earlier this year, and she'll be telling us about Mr. Lee's case today. Our next panelist will be Nancy Aretskin, who's the interim department head of marketing at New Mexico State University College of Business. Nancy is the co-founder of the Southwest Asylum and Migration Institute, an organization dedicated to representing those in need of immigration representation who are financially challenged or otherwise underrepresented. She has long specialized in representing immigrants seeking asylum and has successfully represented numerous asylum seekers in their asylum claims. Her grandparent first arrived to the U.S. through Ellis Island in New York at the turn of the century. And Nancy respects and highly values all the contributions that immigrants make to the U.S. And is very much dedicated to the fight for fair and equal treatment for all migrants. So with that, I'll turn to my piece of the program, which is an overview of where we stand in the detention space. So since 2014, really, so before the Trump administration, we've seen a massive increase in the detention of asylum seekers, such that today there are more asylum seekers locked up in immigration detention than we've seen for many years. This is in part due to the Obama administration's response from the summer 14 onward to the increase or uptick of Central Americans seeking asylum at the southern border, specifically the administration's choice to treat that surge as a problem of border security instead of a humanitarian crisis. And a critical piece of that sort of border security strategy was detention, the use of detention as a strategy of deterrence. That is, we saw the administration put asylum seekers, including families, in detention, not because they had to be detained, not because they needed to be locked up to ensure their appearance in court or to protect the community from harm. Instead, we saw detention being used quite explicitly as a deterrent strategy. People were being locked up to send a message to other would-be migrants that they're not welcome here. The Trump administration has sadly continued down that path and done far worse. The president's executive order on border security in January, as many of you know, announced the end to so-called catch and release policies and committed the administration to detaining people who alleged to be in violation of the immigration laws until their immigration cases are decided. So obviously the administration's ability to actually do that is limited by available detention bed space. But I will note that the White House budget request calls for an unprecedented expansion of detention capacity, particularly in the southern border region. So one of the ways this new detention policy has been implemented is a crackdown on what's known as humanitarian parole for asylum seekers. That is, parole for individuals who present themselves to the immigration authorities at a port of entry to the United States, say a land border or the airport, and make an asylum request. The government's position is that these so-called arriving asylum seekers, that's the term of art, aren't entitled to a bond hearing before an immigration judge. Instead, they're restricted to seeking release on parole from ICE, from US Immigration and Customs Enforcement. Parole is the only mechanism available for their release from detention. Now, the prior administration had instituted a policy of generally granting parole to asylum seekers who were found to have a credible fear of persecution. So basically, if you're an asylum seeker and you established your identity and that you weren't a flight risk, you weren't a danger to the community, you would be released out on parole. That did start changing from 2014 onward. Parole rates started going down, but there's been a precipitous drop in parole under Trump since January 2017. So really quickly, just some numbers. In 2012, about 80% of parole requests were being granted, so 4 out of 5 asylum seekers would be released from detention upon establishing that they had a bona fide asylum claim. That fell to around 50% by the time we hit 2015. And the data we've gotten so far from 2017 in response to a Freedom of Information Act request indicates parole grants are now hovering around 20%. And in some parts of the country, it's 0. There are a number of ICE field districts, field offices, that simply aren't granting parole to anybody. So what does that mean? Well, that means is that thousands of asylum seekers are locked up for months or even years while their cases are decided, and they have no way of getting out. They're going to stay locked up in immigration detention until they either win their asylum claims or they lose and get deported. And obviously, the consequences of that kind of approach are devastating. In addition to being traumatic for people fleeing persecution or torture in their home countries, detention makes it all the more difficult for asylum seekers to fight their asylum cases and coerces people who have meritorious claims into giving up their asylum claims, even if they do in fact face persecution or death back home, because they can't stand being in detention anymore. So what we're really talking about is a regime of punishment. Although the legal fiction, as I'm sure many of you know, is that immigration detention is civil detention. What we're seeing right now, this sort of mandatory mass detention of asylum seekers, is effectively punishing people for seeking asylum, seeking refuge in the United States, even though they have a right to do so under domestic and international law. So what's to be done? Many things, but I'll just talk about one since it intersects with our case in the Supreme Court, Jennings. So for more than a decade now, the ACLU and its partners, some of you are probably on the call, have fought in the courts to advance the due process rights of immigrants subject to prolonged immigration detention, including the due process rights of asylum seekers. As I said earlier, arriving asylum seekers don't get that basic due process of a bond hearing before a judge, even if they're locked up for months or years. Right now, the government gives them parole, which is a custody review by ICE, by the jailing authority. And that system makes immigration detention quite exceptional in our legal tradition. If you look at any other civil detention scheme, civil commitment, pretrial detention in the criminal justice context, all of those schemes require the basic due process of a hearing before a neutral decision maker on flight risk and danger before you can continue locking someone up. We don't have that in the immigration system. And so we've been brought a series of cases trying to establish the right to a bond hearing when you're locked up for a prolonged period pending your immigration case. That work culminated in a class-wide permanent injunction we won in the Ninth Circuit a few years ago that essentially orders bond hearings for immigrants fighting their deportation cases after they've been locked up for 6 months. That case is now pending in the Supreme Court, and I can provide sort of more information about that case in the Q&A. I'll just say right now that it's been quite the saga. We had 2 rounds of briefing and argument before an 8-member court last term. The 8 justices were not able to reach a decision, so the case was reassigned for argument this term. My colleague Ahilan Arulantham with the ACLU Southern California just re-argued the case in November, and before the 9-member court with Justice Gorsuch. And recently we heard that Justice Kagan had recused herself because she discovered a conflict that she hadn't been aware of until very recently. So we're back before an 8-member court again. I guess the last thing I'll say before we move on to the other panelists is, there's a number of key issues in Jennings that, are of great interest to all of us working in the asylum space that will sort of potentially could change the landscape regarding the detention of asylum seekers going forward. So the first question, really the big ticket question is, do arriving asylum seekers have due process rights with respect to their detention at all? The government is arguing that they don't, pursuant to what's known as the entry fiction and a Cold War era Supreme Court case called Mazzei. Essentially, when you're an arriving asylum seeker and you present yourself at the border, you're arrested and detained in the interior, for purposes of at least some aspects of the due process clause, you're still treated as having been stopped at the border. That's what the entry fiction refers to. And so there's a threshold dispute about whether you have due process rights, since under that fiction, for at least some purposes, you're viewed as having as being outside the country. Obviously, our position is asylum seekers do have due process rights with respect to their detention. The entry fiction doesn't change that, but the government is arguing otherwise. So that's the first question. Do they even have due process rights? If they do, what process is due over prolonged detention? Do you get a bond hearing before a neutral decision maker, a judge? Or is the parole process sufficient? Is it okay to give the person a custody review by the jailing authority, even though that's quite anomalous when you look at our legal systems? And then, how do you know when detention is prolonged? How do you know when these procedural protections are triggered? The Ninth Circuit, as I said, has adopted a bright line rule. At 6 months, you get a bond hearing. No questions asked. That's just the rule. Other circuits have taken a different approach to this issue, saying, no, there's no bright line. You really need to do a case-by-case inquiry into whether the person's detention has become unreasonable in length. You look at whether they've delayed or filed for any frivolous motions. You look at whether the government has dragged its feet. And most of these circuits have also required that people go in and file habeas petitions in federal district court to seek a bond hearing instead of having one automatically required at 6 months or some other point in time. I'll say that although this sounds a little technical, it's of immense practical importance. The reality is that the vast majority of immigration detainees, and certainly asylum seekers who just got to the country, cannot file habeas petitions. It's difficult. They're not familiar with the legal system. They may not speak English. And the overwhelming majority of detained people don't have lawyers. So if you compare the circuits that have a bright line rule like the Ninth and also the Second Circuit to the circuits that require people to file habeas petitions, it really is night and day. It's the difference between thousands of people getting that basic process of a bond hearing versus maybe dozens who are able to get it together and file a habeas petition, find a lawyer to file a habeas petition, and then maybe eventually get that bond hearing that will give them an opportunity for release. So we expect a decision in Jennings anytime between now and June, and I'll leave it there, and we can take up any questions all of you have about Jennings or any of the other issues I discussed earlier for the Q&A. So with that, we will turn it over to Sandra.
Thank you very much, Michael, for that really useful introduction and that overview of detention and asylum policy. I want to thank both Michael and Nancy for their excellent work in representing asylum seekers, and also the ABA for inviting me on this important panel. I'm also the child of refugees, actually from Chile, so understand very clearly firsthand the importance of being able to seek protection from persecution in the United States, and I very much hope that that's a tradition that we will be able to continue in this country. I'm in private practice, and so the individuals that I represent generally have funds to hire an immigration attorney. Often they are individuals that are not arriving aliens. As Michael described, they are people that have already either been admitted to the United States because they're here on some kind of visa, or they are lawful permanent residents, or sometimes they are people that entered without inspection but have been in the country for some time. That for people that entered without inspection and have been here for some time, they face other challenges, such as a one-year filing deadline, which is required in asylum cases. But I wanted to make the point that, and kind of piggybacking on what Michael said, which is that obtaining asylum in the United States has always been a difficult process and a challenge for asylum seekers. I remember a few years ago under the Obama administration, I spent a week in Artesia, New Mexico, when the Obama administration was sending that message, as Michael said, to individuals fleeing persecution from Central America. They were sending the message that they shouldn't come to the United States to seek protection by, in fact, detaining kind of hapless women and children in New Mexico. So it has always been a difficult proposition, and we've certainly, over the past few years, also seen the issue of increasing backlogs, both for affirmative and defensive asylum seekers. And that's another, the topic here is whether asylum is really a false sense of relief under the Trump administration. So, we've made the point that it was always difficult. I think perhaps now we have more procedural hurdles. Additionally, there is a stronger likelihood of detention. I think the Trump administration also revamped the idea of who is a priority under the immigration laws. So whereas under the Obama administration, if you had a conviction, say for an aggravated felony or a crime involving moral turpitude, that would make you a priority for deportation. Now, if you have a conviction, you're a priority, but even if you don't have a conviction, but an immigration official believes that you might have committed some kind of criminal act, that puts you higher up on the list of priorities. And really anyone that's here that's undocumented is considered a priority by the Trump administration. So what that means for my clients is that when they apply for asylum, that's certainly a consideration I have to talk to them about. I have to tell them, look, there's a likelihood that you may be detained, just because you're here and you're undocumented. And in fact, I have seen a couple of cases of individuals that say came over on a tourist visa, had even a very minor criminal issue that was later dismissed. They applied affirmatively for asylum, and then when they appeared for their interview, they were actually issued a notice to appear or a charging document and put in removal proceedings at that time. So this is definitely another challenge that we are seeing under the Trump administration. One of the reasons I was asked to be involved in this panel is because I was asked by Human Rights Foundation in 2016. Human Rights Foundation is an organization, a nonprofit in New York, that often handles freedom of expression issues. And because of some previous work I'd done with them, they asked me to handle the case of Amos Yee. Amos Yee is an 18-year-old a citizen of Singapore who basically entered the United States in December 16th of 2016 under the visa waiver program. And he was a very well-known political dissident in Singapore, because when he was 16 years old, he was kind of like a YouTube personality in his country with several million followers. He was a former child movie star, and he produced a video where he basically criticized the former Prime Minister Lee Kuan Yew, and then celebrated his death on this YouTube video, which is something that's not commonly done in Singapore. After that happened, he was brought up on charges of intention to, I quote, wound the religious or racial feelings of individuals in Singapore, and he was jailed because of his because of his right to exercise his freedom of expression, and he was sent to jail for several weeks, and also put in a rehabilitative program in Singapore. When that happened, the case received a lot of international attention. Amnesty International called him a prisoner of conscience, as well as the United Nations Rapporteur on Freedom of Expression issued a very strongly worded statement against the government of Singapore and said that Amos Yee was a prisoner of conscience. When Mr. Yee arrived at Chicago O'Hare Airport under the visa waiver program, he was categorized as an arriving alien. At that point, he was placed in the custody of Immigration and Customs Enforcement after he indicated an intent to apply for asylum. So when we became involved in the case, one of the first things that we did is contact ICE in Chicago to make a formal request for a parole. And in fact, as Michael said, you know, the parole has been around for a long time, and even though the Trump administration issued an executive order on January 25th of 2017, basically trying to limit or abrogate the ability of individuals to obtain parole in favor of detention, there was a subsequent memorandum in February issued by then Secretary Kelly, which seemed to reaffirm that parole was still in place, and the memo specifically referred to a 2009 ICE directive that described the availability of parole and when ICE officers should utilize that. So we, in asking ICE in Chicago for parole, referred to that memorandum, and we, you know, usually, so when an individual applies for parole, what ICE is looking for is they want to ascertain the individual's identity. They want to make sure that he's not a flight risk. They want to make sure that the individual is not a danger to the community, and that there is either a significant public benefit or a humanitarian reason for which the individual should be paroled. It was our argument that that Amos met all of those eligibility criteria. He had also just turned 18 years old, so he was a teenager. The question of identity was not even a question. This was an extremely high-profile case, and there was never any argument that he presented any kind of security risk. So before the executive order, ICE indicated to us that if Amos passed his credible fear interview, he would indeed be released on parole. So once he passed his credible fear interview, we then said, all right, put your money where your mouth is and let's have him released. And then they said, well, actually, now that this executive order has come to light, we are making the decision not to parole him, and he's going to stay in detention through the pendency of his asylum proceedings. If he gets asylum, then we can release him. So we, of course, raised the stink, filed additional paperwork, also highlighting some medical issues. Didn't make a difference. So he had been detained since December 16th. We then had an asylum hearing at the Chicago Immigration Court in March, and we won asylum based on political persecution. And at that point, we then expected the release. After the asylum grant, we were again told by ICE that they would not release him during the appeals period, because once a judge grants asylum, the government in fact has a month in which to appeal the decision. So they hadn't appealed the decision yet. They indicated that they might, but ICE informed us that they would wait to see if ICE would appeal. And in fact, almost on the last day, ICE did appeal the decision, and we were told once again that he would remain detained. And at that point, it wasn't, and so after that, the Board of Immigration Appeals issued a briefing schedule, and it wasn't until September of 2017, so basically 10 months after his original detention, that we got a unanimous decision from the Board of Immigration Appeals affirming the immigration judge's decision to grant asylum. And at that point, Amos was released from detention. And, you know, what's obvious in a case like this is this was, you know, a child, a highly traumatized individual who had been in detention as a 16-year-old and sent to mental health rehabilitation in Singapore. And he actually spent a longer period of time in detention in the United States than he did in Singapore. Just on a final point, on top of that, he was also moved around to 3 different facilities during his detention. And even though we were counsel of record and were in touch with ICE, we were never told when he was being moved from facility to facility. So clearly the detention, and I think similar detentions which are happening across the country, are a violation both of national and international law. I think it's interesting to note that the U.S. played a major role in the wake of World War II in efforts to draft the convention relating to the status of refugees. And the U.S. is legally obligated to treat refugees in accordance with the convention's protections. The U.S. is also bound by the International Covenant on Civil and Political Rights, which prohibits the unnecessary, disproportionate, or otherwise arbitrary detention of immigrants, and also requires a prompt court review of detention. Oh, we're losing power here in Miami. So with that, I'm going to pass it over to Nancy.
Oh, Nancy, I think you may be on mute.
There you go. Okay. Thank you. I don't want to be redundant, and I want to talk quickly because I want to leave a lot of time for questions. So first of all, I want to say, well, why am I included? I'm a department head of marketing in a college of business. I've been a faculty member at New Mexico State for 25 years, but I live on the border. I live in the trenches. I'm 45 minutes from Mexico, and there are 7 border crossings into El Paso. With the civil strife around the world, the El Paso border crossing probably sees people seeking asylum from easily 80 different countries. And just as what was stated, they appear as arriving aliens, and most of them are detained. We're also, of course, very close to Mexico, so there's a large number of Mexicans and Central Americans. One of the things I want to be honest about is the actual asylum process in the detention center is no different after Trump than it was before Trump. So we can't blame Trump for the application of the law that the detention judges are following. The El Paso Immigration Court has 6 judges, and according to TRAC, which is an organization at Syracuse University, the denial rate in the El Paso Immigration Court is 96.6%. So the first message I want to tell anybody and everybody, tell people not to enter through El Paso. Go into Michael's district, go into the 9th Circuit, not the 5th Circuit. It's a major difference and a major deal. The next thing I want to say is, yes, I'm a faculty member in the College of Business. I recognize that a lot of the people in detention can't afford attorneys, and especially the ones in El Paso, because I represent a lot of Africans. And you think Africa, I remember the first call I got 2 years ago from someone from Somalia, and I said, how did you get to El Paso? And when he said I walked, I was like, what? There is this area between Brazil and Ecuador prior to Colombia that thousands of Africans meet, and then they make the trek on land, and many of them enter into the U.S. as arriving aliens, are detained, and if they come into El Paso, 96.6 lose their cases and are deported. Many of these people have been robbed on the way or aren't from family of means and couldn't afford an attorney. So that's why in 2010 or 2013, actually, I started a not-for-profit where I represent, unlike Sandra, a lot of people for free or low bono, or get family members to help keep my organization alive. New Mexico State is a big partner in my organization because I can use the copy machine and the people at New Mexico State to help me with preparing country condition reports. So my practice is a little bit different than Michael's and Sandra's, but I just really wanted to differentiate that. The other thing I want to make clear is that Michael and Sandra have referenced getting humanitarian parole versus bond. Those are issued by 2 different entities. Bond is issued by an immigration judge, and parole is issued by ICE, the field office director. Many of the detainees or their families don't understand that. They think that the detainee can go before the judge and ask for humanitarian parole. Many of these people in El Paso, Sandra, with all due respect, are detained well over 12 months, 14 months for their initial asylum hearing. The few that do win are then detained for at least the 30 days until the government appeals. And if the government does appeal, they're detained during that whole process. I represented a guy from Zimbabwe who was detained for 18 months before his results of his hearing, and we won his hearing. He was detained another 30 days, and the government knew better than to appeal because we had had 20 hours of testimony, and I had submitted 14 submissions, and they didn't have anything to appeal on. But like in your case, the government was dishonest, said they were going to appeal until the last day when he was released. This is incredibly difficult for detainees or their family members in the U.S. to understand, because it's incredible that that is happening in the U.S. just like what Sandra said, people in detention out here in El Paso are moved between 4 or 5 different detention centers, and they don't notify the attorney, and you have difficulty obtaining information from them to submit to the court. And again, if they have no money, I'm using money that I raised through my not-for-profit to get their documents, to get experts, and it's incredibly difficult. I want to just share one particular case with you because that's why I think I was asked to participate. I recently won a case for a woman from El Salvador. She was 21. She had tried to come to the U.S. 3 prior times, so she didn't qualify for asylum because she was picked up inside the U.S., charged with illegal reentry, which is an ag felon, which disqualifies her for asylum. I actually had the case referred to me from the Federal Public Defender's Office. She had been detained over 14 months. And the first time she came, she said she was threatened by the gang. The second, and they gave her credible fear, she failed, was deported. The second time she came was after she was raped by a gang member. She again lost and was reported. The third time she came, she was a mess because the same gang member that had raped her had claimed he owned her, and unless she lived with him, he would kill her family. A judge was flown in from LA to El Paso. She was held in a different detention center than the El Paso one, so she was actually held in Otero, which is in New Mexico, which is the 10th Circuit versus the 5th Circuit. And after she had to testify for the 4th time, because we had 5 different judges, because they were all visiting judges, this judge did grant her withholding of removal, which was a big win. I must say that I think we won because I was able to fly in actual witnesses from El Salvador, fly in a retired Supreme Court justice who testified about the gangs. So my reason for being here is to encourage many of you to take on some of these cases because we're only going to win more when people are represented. And yeah, they're difficult, and yes, it's depressing, but I think it's our obligation as members of the bar to try to participate in trying to fight against this abusive government. I'll stop there because I know that Michael's taking notes and he has some things to say, and then there's lots of questions to come.
Right. Okay, I think folks can hear me. So I think so. Thank you for both of you for those really insightful remarks, and thank you for all of your efforts on behalf of your clients. I very much agree that it's really the work of heroic advocates that in large part make it possible for people to get the protection that they're legally and morally entitled to. And I think we've heard really great examples of that today. I mean, just to tag a few themes for possible discussion, and I know there's a mechanism for people on the webinar or phone to submit questions. I believe they're supposed to show up on my screen, but I will confess I'm not the most technologically proficient person, so you may have to bear with me for a second as I figure out how to view your questions. But so I think one important point to emphasize, perhaps this is obvious to most folks, is that there's no right to appointed counsel in removal proceedings. And so you really do have a representation crisis that predates this administration, in the immigration system. That's especially true for detained folks. More than 80% of immigration detainees lack counsel. And that's for many reasons, but one of them is that it's extremely, it's extremely difficult to do detained cases. Folks are often detained in far-flung locations that are nowhere near urban centers. There are obstacles to communicating with your client when they're in detention. They're vulnerable to transfer, so you could have a client that's detained near you only to have them shipped out under cover of night to Louisiana or to Texas when you're up in the Northeast or in California. And so all of those obstacles make it extremely challenging to do this work, which is hard enough already. So I think one theme that we could go into more deeply is the representation crisis we're facing and have long been facing in the system. Another theme. Yeah,
Michael, if I may comment on that. So I mentioned to you guys a couple years ago when the Obama administration opened the first detention facility for women and families in Artesia. What we found is that, so I worked through an AILA, an American Immigration Lawyers Association project down there where we went and provided pro bono legal services to some of these detained women and children. And in every case where these women had access to counsel, they were able to win their asylum case. So it made a tremendous difference. And in the cases where we didn't get to them on time, we were looking at some of the records, and the immigration judges would actually ask these women, well, what's your particular social group? So, and they would expect them to answer. So for those of us on the call, in order to be eligible for asylum, you have to show persecution on account of one or more of 5 protected grounds: race, religion, political opinion, and one of them is social group. So, and the social group analysis is a highly technical analysis that requires an understanding of case law. And so it's extremely difficult if you're in a situation where you're fleeing domestic violence or gang recruitment, to be able to identify to an immigration judge what your basis of persecution is. And so it definitely makes all the difference. And I think if we're talking about challenges, the lack of representation is certainly one of the most important ones.
And I'll echo that plug, both Sandra's plug and Nancy's plug, for folks who are interested in asylum issues. If you're not already to consider taking on these cases, one of the bright spots in this rather dismal moment for asylum and immigrant rights more broadly is we are seeing more and more initiatives like the one Nancy founded out in New Mexico. I think certainly AILA's efforts with respect to the family detention centers, pro bono efforts like that. I'll also plug the Southern Poverty Law Center's Sci-Fi initiative, the Southeast Immigrant Freedom Initiative, which is somewhat modeled on the work that AILA and others did around family detention, where essentially SPLC has adopted a set of I believe 4 detention centers in the South, in Georgia, in Louisiana, and maybe Alabama, I can't remember, but essentially that they just sort of set up shop and made it possible for attorneys who are interested in coming in to do short-term stints representing asylum seekers and other detained immigrants to come in, work at these remote offices, and fill that representation gap at places that have been black holes, where people do not have lawyers, where there's been no accountability as a result with respect to IJ and immigration judge and ICE practices, where the asylum denial rates are comparable to what Nancy was describing in the El Paso area. And so if you're interested, I'm sure well, please contact us after this, and we can get you hooked up. I see we have a question. What can psychologists, social workers, and other mental health professionals do to support lawyers who are representing asylum seekers? That is such a good question, and I'm actually going to have either Nancy or Sandra take that question, whoever wants to
I'd love to answer that.
So good, guys.
So I have learned in the detained cases that I have, one, if I can get a psychologist in there to do a report to talk about or to document the persecution and the trauma that the judge will accept a report from that professional more so than when I try to make that same assertion based on facts, because the judge will then say that, Ms. Oretskin, you're an attorney, you don't have the expertise to make this assessment. So those of you who are interested, possibly Sandra over there has clients that can pay for the reports. I kind of am always begging people to do free work, and so my list of professional friends has dwindled because they see when I'm coming at them, I'm usually asking them to do something for one of my clients, but it's a big role that people can play to do these assessments for asylum seekers, in my opinion.
And I would absolutely echo that, and I would say that while some of my clients have the ability to pay, certainly not all of them do. And I represent a lot of women who are survivors of domestic violence, and that line of cases is one where women would be qualified for protection as members of a particular social group, women that are viewed as property by virtue of their relationship. I would say that the report of a mental health professional can make all the difference. When judges are looking at asylum cases under the Real ID Act, one of the most important factors that they're looking at is credibility. And so we try to actually have especially in DV cases, we try to have a report by a mental health expert in every single one of those cases, and often those reports will discuss issues like PTSD, and so they'll help bolster the credibility of our applicants. So it's incredibly important.
If I may add one more thing, in some cases in El Paso, when we have been able to get those reports, we've been able to use those to get people released on humanitarian parole, because arguing that the prolonged detention just exacerbates the PTSD or whatever. We've had a number of Afghani interpreters somehow come through the El Paso border and been able to get a few of them released on humanitarian parole. Right. With those reports. Without the reports, no.
Great. I think that's a critical point, that kind of expert testimony plays a critical role both in terms of proving up the asylum claim, so establishing that what the person says happened to them in fact happened to them, but also on the detention piece. You know, as Nancy is saying, that kind of expert testimony, those expert reports can do a lot to help get somebody out by showing that they're being detained in an inappropriate setting. So
can I add one more thing? Just one thing that Sandra mentioned, which is also really important for the El Paso judges. 3 of the 6 judges routinely deny claims on lack of credibility, which means that they never even address the merits of the asylum claim. Mm-hmm. And some of the credibility is based on the type of persecution that some of these people witness, and they can't really totally recall with the detail that the judges required absolutely everything that happened to them. And so the credibility issue now out in El Paso has become a huge issue, and I know a number of attorneys have BIA appeals pending on just this summarily, decision made by some judges where we believe that the detainees were credible. So that is incredibly critical.
So we have a follow-up question on this mental health expert issue. Do you find the judges give more credibility to expert testimony from psychologists or psychiatrists as opposed to LSCWs or LMFTs? Nancy or Sandra, do you want to speak to that?
I'll say we've used both, mm-hmm. really, and I have not had an issue having a licensed social worker qualified as an expert, at least in the courts here in the immigration courts in Baltimore and in Virginia. So I think, you know, if the individual has an established record, and especially if they're acting pro bono, I think that judges give more weight to those kinds of reports. So I don't see that particularly as a challenge.
I agree.
Great. So there was mention earlier of the track statistics regarding asylum adjudication across the country. The question is, what are the rates of disparity in asylum grants among the circuits? And I can provide the start of an answer, but I think it's better always to get a view from what's actually happening on the ground. So I haven't looked at those stats in a while, I will confess, but I know the nationwide average has long hovered around something like 50% grant rates or thereabouts. It's somewhere in the middle. But that average, that national average, of course, massive disparities among the immigration courts, and sometimes even within particular immigration courts. A few years ago, there was a group of law professors who published the systematic study of inconsistencies in the asylum adjudication system. It's called Refugee Roulette, I think is what it was called. It's a book now, and I think maybe Stanford Law Review published it, or one of those law reviews published it. And it showed exactly what you've been hearing on the call today, that, on the one hand, there are some courts and even some judges within courts who are very generous in terms of asylum decisions, and some places in the country where no one gets asylum, even though similarly situated people with the same claims, so Central Americans fleeing gang violence, people with gender-based claims, what have you, same issues, same facts, same claims, same people, same parts of the world, widely different results, and that may have to do with a few things. And we know that folks who are detained who don't have lawyers have a much harder time prevailing. But and we also know that whenever you have a system like ours, where you do have a lot of courts in different parts of the country in different circuits, there is going to be some level of inconsistency. But I think that the scholarly consensus right now is that this kind of inconsistency reveals a very serious level of arbitrariness in the system. And so that's what I'll say at a very kind of abstract level, but I'm sure Nancy and Sandra have stuff to add.
So if I can chime in a second, I provided to the organizers of this the most recent track report, which is 2012 to 2017, and you can, they have two separate reports. They say that asylum denials are, as Michael reported, related to no representation, or they also have a separate report where it's judge by judge decision, and it depends on the judge. There is a huge disparity within the circuit. So I'm very familiar with the Fifth Circuit, which is awful. I mean, we have El Paso, there's Dallas, there's Houston. All of those are, the denial rates are well above 80%. I'm just looking in Arlington, you have a judge that denies at 89.2%. Then you have a judge that denies at 17.1%. So it depends on judges, it depends on circuits. One of the things in El Paso, we tried to do change of venues all the time to California, and you've got to think the change of venue is when they're detained. So the cost to the government is expensive, but we have been successful sometimes, and then what can happen is if we can get a change of venue, they get to California, they have been detained 6 months, they do get out, and a few people have won their cases. The other thing, though, to be honest to some of these judges, because if they ever knew I didn't say this, they would take it out of me later, we're so close to Mexico. There are a lot of people that flee Mexico and Central America because of cartel violence or just gang violence. That in and of itself doesn't merit an asylum claim. So you factor in some of those numbers is why we have the larger denial rate. Plus one other thing we haven't mentioned yet, so I'm just going to say it. One of the legal elements to prove asylum is country relocation. And if people haven't tried to relocate in their country or can't meet the burden of proof, like many Mexicans, they can lose their asylum case based on that. So that's another reason why our rates are higher, but they shouldn't be that much higher than the rest of the country.
Yeah. I mean, I guess the last thing I'll say on this point, you know, to acknowledge some of the important work happening on this set of issues is that, you know, if you are in a part of the country that has high denial rates, that's essentially become an asylum-free zone, that is not cause for despair, but cause to kind of lawyer up and figure out creative strategies, right, to ensure that people who have legitimate asylum claims get asylum. And the effort that immediately comes to mind is Stephen Manning, who's a very you know, a sort of nationally renowned attorney, immigration attorney, and very involved in AILA, and his initiative, the Immigration Law Lab, which is actually taking on these immigration courts that have near zero asylum grant rates, like the Atlanta Immigration Court, for example, working with local advocates, legal advocates, non-legal advocates, to figure out what is to be done, because you know, obviously some people are going to win asylum, some people are going to lose asylum, but it is unacceptable to have immigration courts where literally no one gets asylum, regardless of the merits of your claim, and that your fate turns on whatever part of the country you happen to enter or end up in if you're detained and transferred. You know, if anyone on the call is interested in in kind of jumping into the lion's den, you know, I think we'd all urge you to do that. The next question.
Sorry, this is Sandra. I am now joining by phone.
Great.
So here I am trying to make the best I can do here.
Great. Great to have you, Sandra, by phone.
Yeah.
So the next question is, I've read a few cases where a person with a disability was recognized as being a member of a social group. In your opinion, how likely is it that an applicant with a disability will be granted asylum? So.
All right. So this is Sandra. I mean, so it's every case depends on the specific facts. So as I mentioned before, you know, the social group analysis is based on several different factors defined in case law. So you, to the person that asked this question, you would want to look at how that social group is defined, whether it's socially distinct, so whether individuals in in your applicant's particular home country view individuals with disability as a distinct group, and in fact, you know, part of the social group analysis is that basically that the person has an immutable characteristic and that they are persecuted because of that characteristic. So I think definitely if your client is someone who has been harmed in the past or is likely to be harmed in the future because of their disability, and you can provide, you know, objectively reasonable evidence that that is the case, then he or she might have a social group claim. So again, you would want to go through the case law and see if they could qualify. I also, on the question before about the track report, I'm sorry, Michael and Nancy, I couldn't contribute at the time, but I did want to put a plug in for a report that I found recently that had some great statistics actually about ICE parole and about how even in jurisdictions where parole was being granted before, it's basically now non-existent. And although ICE is supposed to release statistics on this, they don't. But Human Rights First has been compiling statistics, and they're very interesting to look at. So you can Google human rights first. There's a report called Judge and Jailer, Asylum Seekers Denied Parole in Wake of Trump Executive Order. So if anyone is interested in statistics, that's very useful.
If I can just chime in and add what Sandra said. So at the beginning of the discussion of the title of this, A False Sense of Relief, Asylum in the Trump Era, at least where I am in El Paso, many of my clients that are going to have individual hearings in the next month have been detained long before Trump was elected. So, and it's the same judges. So I don't see any difference in the actual deliberation of the asylum cases yet. But there is a huge difference in ICE. ICE now feels that they act with impunity. ICE denies everything. I'm in an area where there has been a large undocumented population for a very long time. ICE is sweeping neighborhoods and picking people up, and our detention centers are completely full, which allows them to remove people from their families so they can't even be visited by their families. That has changed substantially since Trump.
And I would add to that even here, you know, where I normally practice, which is the Washington, D.C. area on the 4th Circuit, where we actually had very, very high grant rates on parole, and in general, when making a request for exercise of prosecutorial discretion, now we are actually also seeing almost everything be denied. So that is definitely a change that we're experiencing in the 4th.
And I want to add one more thing, even though it's not really part of this topic. So under international law, if somebody goes to the border of the U.S. and claims credible fear, by law, the U.S. should parole these people in, and then they're designated as arriving aliens. And as Michael has said, it's a sense of legal fiction, and they're held in detention. CBP, which is different than ICE, at the borders in El Paso, are turning hundreds of people away. So right there is a violation of international law. And I know that ACLU and AILA attorneys have been on the border and are trying to address this with CBP, but I continue to hear from people in Juarez and the centers in Juarez that it's gotten worse. So this is, again, a different issue than what we're talking about. And it's worth mentioning CBP is different than ICE, because CBP is at the border, and now they're acting again with impunity because they believe that there's nothing we, as the independent lawyers trying to keep them honest and provide our legal due rights, can do under the Trump administration.
Great. So the next question, what is the anticipated effect of the U.S. stepping away from the Global Compact on Migration, the New York Declaration for Refugees? And I have to confess, I'm not an expert on that issue, and I do not know the answer to that, but perhaps Nancy and Sandra do.
I do not either.
Not pass. Like I'm going to pass on that one as well.
Okay. Apologies to the person who asked that question. So what are the next steps legally in fighting the travel ban with the Supreme Court allowing it to go forward? And so I can maybe start on that question. And so as folks I think all know, recently the Supreme Court has allowed the government to enforce Muslim Ban 3.0, the Muslim ban or travel ban issued on September 24th, parts of which had been previously blocked by the lower courts in challenges to the ban. So what does that mean? The ban targets citizens of 6 Muslim majority countries: Chad, Iran, Libya, Somalia, Syria, and Yemen. The government can now deny visas to nationals of those 6 countries, including people who have a bona fide relationship with a person or entity in the United States. That includes relatives of U.S. citizens, green card holders from the listed country, as well as other visa applicants. I think the estimate is the ban affects maybe 150 million people, the vast majority of whom are Muslim. The ban also puts restrictions on North Korea and Venezuela, two countries that aren't Muslim majority, but their inclusion will have basically no practical effect for regions we get into. So the Supreme Court has now permitted the government, the administration, to implement the full version of the ban immediately. I will underline, and I think this is important to get out, the order should not impact people who already have valid visas to enter the United States. So if you or you know someone who has a valid visa but are stopped at the airport because you're from a banned country, please email airport@refugeerights.org, airport@refugeerights.org, because we want to make sure that people who shouldn't be subject to the ban are not subject to the ban. You know, in terms of what's next, the cases, you know, challenge the Muslim ban go forward, and we anticipate being back before the Supreme Court fairly soon. The two cases that are probably getting the most attention is the case by the state of Hawaii and others in the Ninth Circuit, and then another case in the Fourth Circuit, the IRAP case that the ACLU and its partners are litigating. We're in fact in the Fourth Circuit tomorrow. Having Cecilia Wong from the ACLU will be arguing the case in Virginia, and so stay tuned for those developments. But I think everyone understands that this is heading back to the Supreme Court. So
I would just like to add a short comment. Okay, so I wanted an asylum claim for a Somali in 2014. We filed an I-730, which is a derivative claim for his wife and son who were in a refugee camp in Kenya. Of course, he's never seen his son because he fled before his son was born. His son is now 4. It took me 2 years, but I did get the I-730 to the Kenyan consulate. His wife and child did have an interview last week, so that took a year and a half. And they did ask for a medical exam, which shows a good faith effort on their part. My client who won his case was detained for 17 months, so my argument is that's extreme vetting in any way they look at it. So I'm interested to see what's going to happen in this case. His wife is fully covered, so they are observant Muslims. So I'm interested to see how the travel ban will or will not affect that case, and I think I'm going to be in touch with ACLU if I need help at some point, because it's kind of bigger than me right now.
Yeah, and I'll add a brief comment as well. The ban is supposed to target, as Michael said, 6 predominantly Muslim countries, but we are also finding that in our consular processing cases, so just to speak in more layman's terms, cases where, for example, a foreign national marries a U.S. citizen and the U.S. citizen has filed a petition for that person to come to the United States. So we are finding in consular posts such as in Lebanon that there's almost a backdoor travel ban going on, where people are the foreign national, even though there may be no security concerns or any criminal issues, they're placed in administrative processing, which means that the cases are pending forever. They're held indefinitely, and the foreign national is being asked to submit an additional form, which is part of this extreme vetting, where they have to disclose all of their social media history, their Twitter handles, their Facebook posts, as well as provide information about siblings. And we're seeing this specifically in Lebanon right now on a couple of different cases. So even though it's not part of the ban, that there's this backdoor extreme vetting going on.
All right, the next question, since we're running short on time. Recently here in the Ninth Circuit, we're seeing an uptick in law enforcement from Central America fleeing gang persecution. How do we best overcome adverse case law stating these police or law enforcement officials, quote unquote, assume the risk in taking on this kind of work? Note that these are current law enforcement officers, not former ones, and there's a parenthesis saying there's good case law for former law enforcement officers. Nancy or Sandra, do you have thoughts?
I only can add on the Salvadoran case that I tried before Judge Laws, who was from LA. And I did bring in the retired Supreme Court Justice who did testify. And one of the things that I believe swayed him was that there's pockets of gang control in El Salvador, not the entire country. And she was very specific in her testimony in identifying those pockets. So going in and just saying the entire country is under gang control is a loser. Being able to be as geographically specific, we blew up a map and had to identify the towns and the counties and identify the gangs and show, corroborate testimony with articles in papers where gang members did different things and the police were or weren't there. So again, it's like preparing for any case. It's a little bit harder because you got to corroborate your claim with as much as you can from El Salvador. That's the best I could offer.
That's right, and I mean, I think as part of that, having an expert testimony is incredibly important. Also, you know, there's a lot of bars to asylum. There is not one about assumption of risk. So
right.
I am not familiar with that case law, but I mean, that is definitely ultra vires to the regulations or to the statute. So it might be possible to make that kind of argument. You know, really what you have to prove for asylum, according to very long-standing case law like U.S. Supreme Court case Cardoza-Fonseca, is that you can prove, you know, at least a 10% chance of persecution. So that assumption of risk, it really doesn't, at least in the cases that I've reviewed, doesn't really seem to fit into that analysis. Also, asylum is granted as a matter of law, but also as a matter of discretion. So you may want to look into the discretionary aspects and equities of the case as well and highlight those to the judge.
Yeah. I mean, I'm not familiar with this line of cases either, unfortunately. You know, I'm wondering if the government is ever trying to make this argument, this assumption of risk argument, you know, with respect to the social group issue, sort of, if there's some kind of argument by the government that, you know, this isn't a cognizable social group because police have sort of assumed the risk in taking on this work, but I just don't know. Sort of. All right, I don't see any more questions in the queue, and we are getting close to time. So Nancy or Sandra, I don't know if there are any closing remarks you wanted to make before we say goodbye. Great.
The only thing that I would say is I think, you know, the administration at this point has the control of the executive and the legislative, but, you know, the final frontier here is the judicial branch. And, you know, while I think asylum relief has gotten more difficult under Trump, I think it's up to the attorneys right now to really just litigate everything wherever possible and file appeals with the district and the circuit courts to try to get the right decisions and as much as possible take the cases out of the hands of DHS and get them to independent judges. So I think lawyers, you know, are going to be the real warriors here in terms of being able to protect immigrant rights.
And if I can chime in and agree, you know, you do lose a lot, so you got to be tough. But I do want to share with you, when you do win a case, there is nothing better than to see somebody walk out and get a job and start over, and it's the best feeling in the world. And we as attorneys really need to continue to have this fight, especially where I am in the trenches in the detention centers.
Yeah, I'll very much echo that as well. I mean, I think folks like Nancy and Sandra, like you've heard today, groups like the ABA and its partners really are doing heroes work to defend people's human rights, their civil rights. We are literally saving people's lives. And so I just would commend my fellow co-panelists for their amazing work on behalf of their clients and their families and communities. And to again, thank all of you and the ABA for spending some time with us today to learn about and think about these very challenging and urgent issues. You'll recall there were a lot of calls to action over the course of this seminar, a lot of suggestions about how folks can get involved who are not already involved, either as a lawyer or a psych expert or an advocate in some other capacity. So if you're not already or looking for ways to get involved in the work, we'd strongly urge you to get involved. And with that, I think we'll close. I don't know if I need to do anything more than say goodbye, so I'm just going to say goodbye. And if the ABA folks want to weigh in and say formally close the session, that would be great.
Well, Michael, this is Paula again. Thank you so much, Michael, Sandra, and Nancy, for such an engaging and interesting panel. We really appreciate you guys taking the time and answering all of these questions. So thank you so much. For those of you watching, thank you for attending this great panel. And please, if you want to check us out, we will have a posting on our website. We will have a few handouts from our panelists that we can provide to you, and we'll send via email to those that have been registered. But please check out our website for other great webinars and podcasts. And if you like what you see, join our section and work with us and do other great programming and policy work. Thanks again, everyone.
Bye. Thank you.
Bye.
Bye.